I want to thank everyone for joining us this evening. My name is Kimberly Kay with the Legal Insurrection Foundation, and I'm very excited about our discussion this evening, where we will be discussing and maybe even debating whether or not we have a constitutional crisis as we look at the ongoing battle between judicial powers and executive powers. So I'm very excited about the panel that we have. Before we get into it, just a couple of housekeeping things. We will be taking questions at the end of the program. So if you have questions for our panelists or just a question in general, as it pertains to the discussion that we're having tonight, please be sure to put those questions in the Q&A section. I'll be watching those and moderating those questions as we get to that portion of our program later in the evening. If you would like to chat, please feel free to do so. We have the webinar chat where you are able to engage with each other. You're able to engage with the panelists as well. And we encourage you to do that. We do ask, it's just the mother in me that feels compelled to remind everyone to consider focus and kindness and kind words while we're doing that. So we've never had a problem so far, and I don't anticipate one, but I know some of these issues can be very contentious, and sometimes it can get a little bit heated depending on where you fall. This program is brought to you by the Legal Insurrection Foundation. We are a 501c3 nonprofit, and we do all of our programming for free, of course, because we care about these issues, and it's our goal to foster discussion and further education about these kinds of things. If you do enjoy this program and like the work that we do, then I'll put a link in the chat section later. Feel free to continue to support our work. We run a very lean operation, and every single dollar goes right back into our work and programming like this. So without further ado, I want to first hand it over to Professor Jacobson. Well, actually, before I do that, I got ahead of myself. I want to introduce our panel. And so, of course, we have our fearless leader, Professor William Jacobson, who is the president and founder of the Legal Insurrection Project, where we have two other very large projects, the Equal Protection Project and criticalrace.org. He's also his regular day job. He's a securities law clinic professor at Cornell's Law School. So always a pleasure to be able to do these events with Professor Jacobson. We also have Professor Reynolds. Some of you from the internet world may know him as Instapundit. That's how I came to be aware of him many more years ago than I'm going to disclose. And he's a distinguished professor of law at the University of Texas College of Law, where he teaches constitutional law, administrative law, and a handful of other courses. So we're thrilled to have you with us tonight. And last but not least, we have Will Chamberlain, who I've also followed online and followed his work for many, many years. And he's senior counsel of the Article 3 project, which is just perfect for tonight's discussion. So we're thrilled to have him here with us as well. And so I think Professor Jacobson has a couple things to say before we get into general discussion. And again, thank you all for joining us.
Yes, thank everybody for coming tonight. I'm going to save most of my comments to the end. Do want to say I'm thrilled to have these two people here. It's not an overstatement to say that legal insurrection would not be what it is today, but for the kindness of strangers on the internet. And one of the kindest strangers that I bumped into in 2008 was Glenn Reynolds at Instapundit. A lot of you, I bet, found legal insurrection through links at Instapundit. A lot of people have told me that. So it's really thrilled and appreciative to have him here. And Will Chamberlain, too, I've been following mostly on X, which is where a lot of the dialogue takes place these days, a lot of the hot button issues. And he's been a tremendous voice for clarity on separation of powers and the rights of the executive branch in our constitutional structure. So I'm really thrilled to have both of them here. Just to give you a 1 minute, 10,000 foot view of why we're here. We're here because, as the New York Times reported in November 2024, right after the election, and I'll read it to you, the Democrat effort to oppose the upcoming Trump administration will rely on the work of hundreds of lawyers who are being recruited to combat Trump administration policies on a range of Democrat priorities. Already, advocacy groups have been workshopping cases and recruiting potential plaintiffs to challenge expected regulations, laws, and administrative actions starting on day one. Democracy Forward, a legal group formed in 2016, has a multi-million-dollar war chest and marshaled more than 800 lawyers to press forward against the new administration. According to some trackers that I've seen, north of 300 cases. One says 303 cases, but I'm sure it's more than that because every day new cases are added. And that is why we're here. And that has raised a lot of issues as to whether they are creating a crisis, whether the Trump administration is creating a crisis, or maybe there's no crisis at all. I'm sure we'll talk about that. With that, I will turn it over to Professor Glenn Reynolds.
Hi, I should stress that I'm actually a professor at the University of Tennessee, not that other upstart UT, the University of Texas.
Which I'm an Aggie and I know better. I'm sorry. My head was just in Texas.
Well, I mean, they stole our acronym. They even stole our orange and white colors. But sorry, there would be no Texas without Tennessee. You cannot say the reverse. So I just thought I'd get on record with that early. So constitutional crisis. One of the things we know about a constitutional crisis is it's only a constitutional crisis if Democrats aren't getting what they want. So that's the first rule. It wasn't a constitutional crisis when FDR was unrolling the New Deal. It wasn't a constitutional crisis when the Supreme Court made a lot of new law in all kinds of areas in the 1960s and 70s. It was only a constitutional crisis really when people started trying to roll some of that back. I did see a really nice comment on, I think, X today. I don't know who it was from, which said that the real constitutional crisis began in 1913. And of course, there's a pretty good argument for that. That was the year we passed the 17th Amendment, which produced the popular election of senators and really changed the constitutional structure and incentives of the federal government in very drastic and not necessarily obvious ways, and led to an awful lot of the things that we have now. And of course, the other was the creation of the income tax, which gave the federal government a lot more money to play with and a lot more tools of control via the tax system that were not always so obvious and transparent either. But we've had constitutional crises before. One of the things people talk about is that it would be unprecedented if President Trump were to refuse to obey a Supreme Court order. And yet, in the seminal case of Marbury against Madison, Thomas Jefferson actually announced in advance that he would not obey a Supreme Court opinion ordering him to turn over the commission to Marbury. So he basically announced at the beginning that he wouldn't play ball if he lost. And this, of course, led to cleverness on the part of Justice John Marshall, which has been celebrated by generations of law professors, as he managed to pretend he hadn't lost before he started by endorsing the power of judicial review, which, to be fair, was already widely accepted, and save some face that way and get at a few digs at Jefferson. But the fact is, Jefferson announced at the beginning he was not going to comply with the court, and that was not even really a constitutional crisis because everybody said, well, that's a real problem for the court. What are they going to do since the president won't go along with the court's opinion? Nobody said, oh, it's time to impeach Jefferson for even announcing he wouldn't comply with the court order. Then, of course, we had Andrew Jackson, who flat out defied the Supreme Court order and said, to be fair, he said it to the fairly odious Chief Justice Taney, that he's made written his opinion. Now he can try to enforce it. And we've had other examples down the line. The court, of course, has more prestige now, but less than it had a few years ago. We'll get to that in a little bit. And the Trump administration, I have to say, has been very smart not to simply decline to follow Supreme Court opinions. It has, in fact, complied with the letter of the opinions, though sometimes in fairly narrow fashion. And it has allowed this to pile up, which I think only strengthens its position should it declare at some point that the courts have gone out of bounds and that it needn't listen. And I think they're very smart not to have done it yet. I think we may very well come to that. And when we do, we'll be told it's a constitutional crisis again. But I want to suggest if there's any crisis, it's in the creation of a new rule of law. Adrian Vermeule, who's a law professor at Harvard, said the federal court seemed to have come up with a new principle of jurisprudence, which is that whatever some previous president has done, President Trump may not undo. And that does seem to be sort of the gist of an awful lot of these opinions. It's also the case that you see not merely the courts, but a lot of the bureaucracy and indeed most of the Washington establishment treating President Trump, a man who was elected for the second time by a majority of both the popular vote and the Electoral College, and not a slim majority, as if he's a sort of provisional president, a president on probation, a not quite real president now. And I think that that is also a constitutional crisis of sorts. One of the things we have to have if we're going to have a functioning republic is that people have to agree to abide by elections and to treat the people who win the elections as elected. And if you're not willing to do that, and Democrats have basically not been willing to do that for decades, then it's very hard to have a functioning republic. And you could argue that we, at this point, really don't. So what do we do about it? And that's a tough question. The Trump administration, as I say, has, I think, been giving them enough rope, and I think that's very wise. I heard over 300 cases. One statistic I heard was that in the first 2 months of the Trump administration, we had more TROs issued than in 4 years against the Biden administration. That's a temporary restraining order, which a federal court can issue without even a hearing in which both parties are present. There's been a lot of that. And sort of related the treatment of the ACLU and its attorneys by many district judges as if they are not parties so much as part of the judicial system themselves, which I think is how the ACLU views itself. So what are you going to do? Well, there have been a number of proposals. One proposal has been to bring back what was the law from 1910 till 1976, which was that some actions could not be taken by a single district judge, but had to be taken by a three-judge district court. And it was actually a district court made up of the original district judge, another district judge assigned by the circuit, chief judge of the circuit, and a circuit judge for a total of three. And those three decided the question, and then it went straight to the Supreme Court. We got rid of that in the 70s, partly because people thought that it put too much work on the Supreme Court. The Supreme Court is now deciding about half as many cases as it did in the early 70s. So I think we can pass on that reasoning. Now, that didn't apply to TROs, but it certainly could. I think Congress should revisit that legislation and reinstate a somewhat broader version of the three-judge district court. John Lucas, who's a lawyer, a very smart guy, has a Substack blog called Bravo Blue, suggested that there be a requirement that the three judges come from different circuits, which is also not a bad idea. We also could increase the size of the courts. I think just out of a sense of pure mischievousness, I would like to take some of the Democrat bills that were introduced in the last administration to expand the Supreme Court, to expand the federal judiciary, and just ram them through. They were going to add a whole bunch of district court judges and court of appeals judges. Some of the bills were going to expand the Supreme Court to 13 justices. Some were going to expand it to 15. I think the Republicans should take the most aggressive of those and say that in a spirit of bipartisanship, they are going to pass those Democratic bills and they're going to suspend the filibuster so that they can go right on through. And they'd be doing what the policy experts want, because the National Judicial Council last year in January of 2024 called for increases in the number of judges in both the district courts and the courts of appeal. And I would especially add a lot of new judges, the District of New York and the District of Columbia, because they just seem to have been awfully busy lately. So those are the sort of things we could do. And the other thing, just as a note, much of this is driven by the fact that John Roberts is a wuss. And not only is he a wuss and a trimmer, he's a not very good wuss and trimmer. John Roberts worries a lot about the legitimacy of the court, but when he talks about legitimacy, He's basically means in the eyes of the Washington Post and New York Times editorial boards. The truth is, the court's in a terrible political place. It has very little power of its own if people don't voluntarily comply with it. The left has been attacking the court for years. Now the right is like, what are you guys? What's wrong with you? You're changing your position based on who's president. That can't be right. You don't look legitimate to us. If there's nobody left who sees the Supreme Court as legitimate, at least nobody of any political consequence, I don't know what Roberts thinks the court is going to do. But he's not that great at this stuff. He's a judge. He's not a politician, but he thinks he is. He's not nearly as smart as John Marshall, which is, who is, not many people, but definitely not him. And nobody respects a trimmer. And he is a trimmer par excellence. So I think that if the court doesn't change its ways soon, it's going to face a very substantial loss of influence, and it will have nobody to blame for that but itself. This is my stopping place.
I was just about to ask. Thank you so much. Thank you for that.
Tried to stay at my time limit.
No, I appreciate that. And now to you, Will.
Well, thank you so much. And it's great to be here for a legal insurrection event. It's also great to be here with Professor Jacobson and Professor Reynolds, who, when I was in law school, I followed. And even now, my dad is not much of an X user, but he is an Instapundit reader. And so occasionally Professor Reynolds posts some of my tweets, and that's how my dad finds out about them. So it's kind of, it's really gratifying to be here as a result. So the topic today, constitutional crisis. I think there is one, but you're told it's being created by the president. That might be 10% true, and really it's 90% being created by the judicial branch. I'll say it's the 10% true because this Trump administration is substantially more legally aggressive than the last one. That's certainly true. They're pushing back on more settled understandings of the law. Good example of that would be birthright citizenship, and trying to contest that. But that's just one of many areas where the Trump administration is being aggressive. DOJ is another good example. They're being aggressive with Harvard. So they're challenging a lot of settled understandings of the law, and so it's not surprising that there's judicial pushback. And I think that's a good thing, just at the outset, because I look at Elon's manufacturing process. If you read his book, his whole idea is that you should be removing parts of your manufacturing process, and if you don't have to reinstate at least 10% of them, you're not deleting enough of them. The idea being that if you're not, and I guess, paraphrase or analogize to the legal field, if a presidential administration is never losing at the Supreme Court, then it's not being aggressive enough with its initiatives, because there's an inherent ambiguity to law, uncertainty to legal outcomes that mean that you should be, if you're never losing, it means you left a whole bunch of free money on the table in terms of things you could have done with policy. But anyway, that's enough of what that's all I'll say about the administration's fault, because I think most of it is just them, being aggressive. That's 10%. 90% of it is the judicial branch wildly overreacting in ways that are obviously lawless. And I'm focusing on immigration today. I mean, there have been 28, as far as I can tell, at least 28 different temporary restraining orders or preliminary injunctions imposed on the administration just in relation to immigration enforcement. And I kind of want to zoom in on two cases that I'm very familiar with, but that I think highlight kind of what the courts are doing and why it's so obviously lawless. So first, there's the Alien Enemies Act case that I'll kind of talk about at the beginning. Now, there's a lot of Alien Enemies Act cases because there's been a lot of complaints filed all over the country challenging deportations under the Alien Enemies Act. But there's two opinions in particular that really highlight what the courts are doing. So one is this district court opinion down in Texas. I forget the name of the judge. It might be Judge Rodriguez, but he was a Trump appointee. But they challenged deportations under the Alien Enemies Act, and this judge argued in his opinion that the current state of affairs did not constitute a predatory incursion, and therefore Trump's invocation of the Alien Enemies Act was invalid. Now, the problem with this is, in every other context that I can recall through my time in law school and being a lawyer, whenever the questions about whether or not questions of war and peace and intelligence and military readiness, whenever a judge was presented with them, there was just this automatic deference from the judicial branch to the executive, because there's a capacity problem. Judges have 4 law clerks. The executive branch has the entire national security apparatus in the military. Clearly, one branch is more well situated to deal with these questions than another. And that's also why the president is the commander in chief of the military. The president is the sole organ of the United States in regard to foreign affairs. Our Constitution structures the government this way, gives the president all these foreign affairs authorities, and gives the judicial branch nothing in this area. So normally you'd see this deference. And yet you have this judge in Texas saying, I don't really think there's a predatory incursion. Well, that's not your call. I mean, even if you, for whatever reason, think President Trump's, invocation is borderline or marginal, it's just not your call to make. It's not you don't have the ability to collect the evidence necessary. You don't have the information the president has, and it's not your department. It's not your department. And so the fact that you even had a district court judge, a Trump appointee, come out with an opinion like this, it was so flagrant, was just and that's just one really good example of the kind of aggressive encroachment on Article 2 authority that we're seeing from the judicial branch. The other one is the Supreme Court's actions of recently. So a lot of people would have seen that the Supreme Court came out with an opinion, I think either yesterday or the day before, on the Alien Enemies Act. And what they were doing was affirming the injunction they imposed 3 weeks ago, stopping the government from deporting a putative class of aliens who were about to be sent to El Salvador. The problem with this is not, we haven't even gotten to substance yet. The problem with this is that the Supreme Court violated its own precedent flagrantly on the jurisdictional question involved here. And it helps to understand the timeline of what happened, because we talk about Marbury versus Madison. One of the substantive holdings of Marbury versus Madison is about the limits of the Supreme Court's original jurisdiction. The Supreme Court is a court of review, not first view. It only has original jurisdiction in a narrow set of defined and circumscribed cases. Cases like when one state is suing another state over water rights. Then it goes straight to the Supreme Court with no lower court involvement. In every other instance, there's a lower court that has given an opinion, and then the Supreme Court reviews it. So in the Alien Enemies Act case that the Supreme Court was just talking about, the ACLU, it's actually wild what they did. They literally called up the judge and were like, you need to issue an order stopping this deportation right away. That's ex parte communication. It's not allowed because obviously the other side is prejudiced by not being able to hear what you told the judge. But then the judge essentially put on the record, like, file your motion, we will give the administration 24 hours to respond. The ACLU files their motion, says nothing, and then shows up the next day and is like, if you don't rule on this motion within the next 40 minutes, we are appealing it, treating this as a constructive denial. And when we appeal it, we divest you of jurisdiction. The district court wasn't acting slowly. I think they ruled within a few hours, but that wasn't fast enough for the ACLU, who went immediately to the Fifth Circuit. And then they did the same thing with the Fifth Circuit. They said to the Fifth Circuit, you need to rule on this immediately. If you do not rule, we are going to appeal it to the Supreme Court and divest you of jurisdiction. And the same thing happened. They went up to the Supreme Court extraordinarily fast. The Fifth Circuit issued an opinion within 24 hours. Didn't take long. Within 24 hours. But by the time they were ready to issue that opinion, it had already gone to the Supreme Court. So what this means is that the Supreme Court ruled on this case before there was even an underlying opinion. And theoretically, this could be justified in a world where a district court or an appellate court sat on its hands for months in a case of some urgency, or sat on its hands for an extraordinary length of time, but certainly not a case where they sat on their hands for either 40 minutes or even a few hours. And Justice Alito at the time wrote an opinion being like, we don't have jurisdiction because there's no underlying opinion, and reiterated it this time. And what you had from the Supreme Court, the majority opinion in this case said, well, they needed to act with more dispatch. They waited 14 hours. Well, 14 hours included a time of sleep. I mean, the motion was filed, I think, in the evening, and they got to it in the morning or something. So it's that's deceptive in its own right. But two, it took 3 weeks for them to put out this opinion explaining why they imposed an injunction 3 weeks earlier that was lawless. I mean, hold yourself to the same standard. What do you mean, 14 hours isn't enough? And I can only imagine that every district court and appellate court judge who's not involved in the dispute is looking at this like, are these people really going to say that it's okay to appeal if I don't rule within 12 hours? What are they like? My business will be impossible to do at that point. So they completely lost their mind on the procedural questions. And you compare this to Texas versus the United States, which is a case that happened during the Biden administration, where Texas and a few other states were challenging the guidelines for enforcing immigration law that basically said we're only going to enforce immigration law against criminals. That in that case, the district court enjoined the administration, told them you have to enforce immigration law. Fifth Circuit agreed. The Supreme Court reversed and said there was no standing. And that Supreme Court is filled with all these arguments about the need for the court to respect the rules and limit its own jurisdiction and not go too far, and just all this respect for procedure and the executive branch, blah, 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 blah. And it's like the moment Trump takes office, that just evaporates. And all of a sudden the court is freaking out and reaching and being like, the ACLU's on the line, better do exactly what they say. It's nuts. And that's, going back to the original thesis, the creation of the constitutional crisis. The second case, and I guess I'll be a little briefer because I don't want to keep us here all day. I want to let you have questions, but is the Abrego-Garcia case that I want to talk about. Now, I've written a lot about this on the questions of his MS-13 membership and what the actual dynamics are in the case. I think it's very substantively interesting, but that's not really the central dilemma when it comes to whether or not there's a constitutional crisis. The crisis here is that the courts are reaching again into Article 2 to try and fashion a remedy and being very vague and gamesy to try and avoid being slapped down or doing something that was obviously lawless. So the basic problem is this: the Trump administration has admitted that Abrego-Garcia was wrongfully deported to El Salvador because at the time he had a withholding of removal that said, you are an illegal alien. You can be deported anywhere, but you can't be deported to El Salvador because you have a credible threat of persecution on the basis of some protected status. So they admitted that they shouldn't have deported him to El Salvador, but once he's in El Salvadoran hands, the ability to bring him back is now a function of foreign affairs, right? It's a diplomatic issue. Abrego-Garcia was a Salvadoran national in a Salvadoran jail. He's not President Trump is not going to send in special forces to retrieve him. And while he certainly can engage in diplomacy to try and persuade and cajole Nayib Bukele to release him for the benefit of our legal system, doing so is not something that's within the Article 3 judge's power to order. And so you have this judge being like, you need to facilitate his return to the United States. And they're saying, you can't order us to yoink him or to do diplomacy. Can you be more specific? And she was like, no. It went up to the Supreme Court. The Supreme Court lectured endlessly the government. This opinion is really arrogant and dramatic about, the failures of the government and how they need to bring him back. And they said, you need to facilitate his release from custody in El Salvador. And the district court should clarify what that means in terms of the specific steps. But they were really indignant. This wasn't a great opinion. It also pretended that it was affirming the lower court holding when it really was reversing it, because there was an element of the lower court holding that it found unlawful, namely like any attempt to force the government to effectuate his return. And then so finally, it goes back to the district court. The district court doesn't do anything to modify their order meaningfully. They just remove the word effectuate, say, you need to facilitate his return. I'm not going to spell out what that means, but you need to do it. And it's, again, the Article 3 court's not recognizing this. Is something also Professor Vermeulen pointed out. He's a really good follow if you don't follow him. Professor Vermeulen pointed out that not every wrong has a remedy under our court system, because we don't live in a juristocracy. We have a balance of powers. There's limits to the authority of the courts. So sometimes they're going to have to say, I can't fix that. You might be right. You might be harmed, but tough luck. That's the way it works. And this is a classic case where that should be a tough luck case. Like, yes, you were harmed. There are remedies we can order you. Like perhaps the family of Abrego-Garcia could get money damages for his wrongful removal. But the idea that they can order him returned when he's already in Salvadoran custody just never made any sense. It's another indication of what the actual crisis here is. It is Article 3 encroaching on core Article 2 authority.
Thank you so much for that. Before I move on to Professor Jacobson, if y'all have questions, and I know you do, be sure that you're putting them not in the chat section, but that you are putting them in the Q&A section so that I know to look for those. So, Professor Jacobson. You're muted, Bill.
Okay.
There we go.
I think I was like triple clicking. So when I was unmuting myself, I was actually remuting myself. So yeah, I think the way I look at it, and I've been concerned with all these questions, all these issues, is it seems like a lot of the federal judges are personally invested in a lot of these cases. And the one that really, there's two that really jump out at me. One was one of the very early cases, and I don't remember the judge's name. I never heard of him before, even though he'd been on the bench like 20 years in the Southern District. But I do remember what he did. At 1 a.m. on a Saturday morning, he issued an ex parte temporary restraining order. That means it was without giving the government a chance to be heard, not so much as a phone conference or anything, on a petition filed at 10 p.m. on a Friday night, okay, with regard to access to Treasury payment systems. And I forget what group it was, went running into court at 10 p.m. because they knew they would get the emergency duty judge in the Southern District. Southern District, I don't know if all district courts have this, but it's one of the premier larger districts in the country. So they always have a judge on duty. You can always get a judge. And so they knew who the emergency duty judge was, and that's why they filed at 10 p.m. And they get, again, I don't even remember his name. And 3 hours later, he issues an ex parte emergency restraining order, which by its terms prohibited the entire political leadership of the Treasury Department from accessing Treasury Department systems. It essentially decapitated the Treasury Department. It was so outrageous that when they finally did assign the full-time judge, the regular judge, she scaled it back on Monday morning or Monday afternoon. But that told me that some judges are viewing themselves as part of the resistance. When you have somebody running into court at 10 p.m. saying there's an emergency, that all this private information is going to get shared widely, all these people have access to it, most of which was not actually true. It was a very limited set of group of people. You can't even wait until 10 a.m. Saturday morning and call a 9 a.m. conference for everybody or hearing. And that told me that a lot of the judges are viewing themselves as part of the resistance. And I think we have seen that pattern repeat itself. Famously, Judge Boasberg, as Will indicated, anybody who's practiced at all in federal courts knows the first thing the judges do is look at, do I have jurisdiction? Are we in the right courtroom? Do the parties have standing? You have to jump over so many hurdles if you're a mere litigant to get into federal court and get a judge to listen to you. And all of those standards, or many of them, in many cases, seem to have been thrown out. There's a lot of cases involving termination of contracts. And that's hugely important. Anybody who I think attended, I forget if it was our February or March event, knows that I think one of the most significant things that the Trump administration is doing is cutting off the funding to the NGO, left-wing NGO/DEI industrial machine. Cutting off, we didn't know that billions of dollars were flowing to the left wing in this country from the federal government. But those cases shouldn't even be in federal court. Those are essentially breach of contract cases with the federal government. You have to take those to the Court of Claims. So why are judges ruling on these things? And so that's another thing. And that's been a lot of the education cases that I've looked at. And there, was a case where there have been multiple cases where either Court of Appeals or the Supreme Court has issued a stay, but on injunctions related to grant payments, because it really shouldn't even be in federal court. And the other thing is the issue of nationwide injunctions. That was just argued in the Supreme Court on Thursday. And that has been another problem. There have been, according to what both the justices and counsel said at argument, there have been, I believe, 40 or so, I forget what the precise number is, but call it 40 for this purpose, nationwide injunctions issued against the Trump administration. So a single district court judge issues an injunction that applies nationwide and applies to every people who aren't even in the court, parties who are not in the court system. And of those, according to what was said at the oral argument, 35 have come from 5 judicial districts. So what you're getting is all of a sudden the district court in Rhode Island is on the map. People are talking about it. One of the sleepiest courthouses in the country, okay, is now multiple major lawsuits being filed there because they know they're likely to get, and I think they are good judges, but you're likely to get a more sympathetic judge in Rhode Island or Massachusetts or some of these other places. And so that's another thing that we're seeing is, and that came up in the oral argument. I think it was even Justice Kagan said, you know, conservatives during Biden ran to the Northern District of Texas or one of the districts in Texas, and now everybody's running to blue districts. And that's what we're saying. But it's the volume of the cases. There were not 300 plus cases filed against the Biden administration. I doubt there were that many in the entire 4 years, but there certainly weren't in the first 4 months. So it's the some judges who are acting like they're emotionally involved, that they view themselves as part of the resistance. They're issuing nationwide injunctions, and they're not examining their own jurisdiction and whether venue is even proper. So in the famous case of the planes being ordered to turn around by Judge Boasberg, that's on the invocation of the Alien Enemies Act, you know, he didn't really seriously consider whether they should have even been in his court. And ultimately, the Supreme Court ruled there was no venue in DC, and he shouldn't have even been ruling on it. And so, you know, just to kind of wrap up my piece, you know, we're seeing a lot of cases that by deliberate strategy of the Democrats of organizing hundreds of lawsuits, going mostly to blue districts, blue district courts, and judges who seem to be personally invested and view themselves as part of the resistance, issuing injunctions, which means that the Trump administration needs to win every single case because on any given issue, because when the opponents, the Democrats essentially, only need to win one injunction, but the administration needs to beat them all. And a Supreme Court, which has been very hesitant, as was indicated, overly cautious in getting involved. Early in February, I said, you know, John Roberts needs to start doing his job. That I think it was in reaction to that Southern District case I mentioned with the 1 a.m. Saturday morning injunction, that if they don't get involved putting in stays early in this process, things are just going to metastasize and expand, and they have. And the Supreme Court's been very hesitant to get involved. And I don't know if there's a constitutional crisis, but I think there's a credibility crisis. I think there's no question that the court system, which came into this administration with the lowest, not favorability, it was one of the major survey companies that does it every year for decades, trustworthiness, lowest trustworthiness ratings ever in the fall of 2024 in the judiciary. And I think it's got to be lower now. So all in all, I think there are major problems. I think it's affected education a lot. A lot of the Trump administration's initiatives have been stymied. That's all the bad news. The good news is if you support the agenda, we're only in month 5 of a 4-year term. So I think they've slowed things down a little, but you know, the shock and awe, a lot of it is going through. A lot of his actions have not been challenged because they can't be challenged, such as government hiring, such as government contracting, as opposed to government terminating contracts. And so I think the political process will work it through, but it's been a very ugly first 4 months.
Thank you for that. So we are going to go to questions now. And before we get into questions from our audience, I have a couple questions myself. So I think we'll start there. My first one for Professor Reynolds, I know that Professor Jacobson just says that he's not sure if there's a constitutional crisis. What are your thoughts on that specifically?
Nobody seems to know what a constitutional crisis is, other than that Democrats are exercised about something. So it's very hard to know. I guess if you want to say constitutional crisis, what you have to say is that there's a disagreement between the branches as to what the Constitution permits or requires, and that neither is willing to abide by the other's interpretation. We don't have that yet. The Trump administration has so far been pretty meticulous about obeying, at least technically, the court's rulings. And so at the present, I'd say probably not. We have the threat of a constitutional crisis because the more of this that goes on, the more likely it is that the Trump administration will at some point simply say, we are no longer entertaining judicial challenges to our actions in these areas. We think they're core Article 2 responsibilities. We think the courts have no jurisdiction on this under separation of powers, and we are not even going to appear in court to challenge them. We are preemptively declaring those are unconstitutional, and we will seek remedies as available against people who try to do anything about it. And that is possible. It is not unprecedented. It's basically Andrew Jackson. It is to some degree FDR, who in the case of ex parte Quirin, which involved some German saboteurs who had a habeas petition in front of the Supreme Court, he made clear to the Supreme Court that if some marshal showed up with a writ of habeas corpus, he was not going to listen and was going to turn them away. So it's not unheard of to do that. And while it's never happened at this scale exactly, we have never had the federal judiciary in significant part regarding itself as part of the resistance to a duly elected president. And the notion that any part of the federal government, but especially the judiciary, is in fact part of a resistance to a duly elected president is the constitutional crisis to the extent there is one right now.
Excellent. Thank you. Thank you for that. It's a great explanation. Professor Jacobson, I know this is something you and I discuss a lot on podcasts and other forums, but how will we know when we have reached a breaking point with all of this? Like, what, to your mind, what are the hallmarks there?
Well, I think it will be if and when the Trump administration says we're not going to follow what you just issued. We are not going to follow it. We do not think the court system has authority over, and it probably will be in something in international affairs or national security. And we don't recognize it. And I think that will be the breaking point. I think I agree with Glenn that the administration has been very cautious. If you're going to pick that fight, if you're going to do that, it better be over a really important issue, one where you think you will have the public support. I think that the immigration one, trying to expedite the removal of the Venezuelan gang, wasn't quite as egregious enough to pull the card there, but it's going to be where the judiciary does something so out of line that threatens national security and threatens the conduct of international affairs. I don't know if they'll go there. It may not happen, but I think that would be the breaking point, a refusal to obey a judicial order. And who knows what then?
It would be one amazing media meltdown if we actually get to that point, though. So it'll be interesting. And this one is for Will. What do all of these things that we've talked about, what does this say about Justice Barrett, who I know has been to many a huge disappointment?
Yeah, Justice Barrett has not been good. It's just she's been, I mean, I think we got sort of sense that she was, a devout Catholic and good on life, but I feel like she imbibed much of the liberalism of being a law professor and working at a law school, unlike the professors who are on the panel with me, who've proven themselves immune to that. But no, it's these cases aren't good. I mean, and in particular, Justice Barrett has a concurrence in Texas v. United States. Again, one of these very heavily on the, we need to be procedurally careful, blah, blah, blah. And then, she's reaching aggressively to decide, a case before there's even an opinion here. So yeah, I think Justice Barrett's a pretty substantial disappointment. I mean, she's not sued her yet, but I'm worried she said it that way.
Certainly seems to be. So this question actually comes from our audience, and this is a separation of powers question, probably for Professor Reynolds. Why should the executive be subordinate to the judiciary if those branches are co-equal?
Well, this is a long-term question asked by many, and the notion that the executive should not be subordinate to the judiciary has been challenged by people from FDR to Abraham Lincoln. Abraham Lincoln said, of course, the judgment of a court is binding as between the parties in the case, but the notion that a group of unelected judges can make a decision for the nation as a whole undercuts the whole notion of democracy. That's not me, that's Abraham Lincoln. Be fair, he was a Republican, so he probably wouldn't be part of the resistance, I guess. But it, that is the very question. Normally, of course, the rule is that court's job is to decide disputes, and when they do so, they also decide the law to a degree, and that normally, even if he doesn't feel formally bound by it, that the president, the executive, will go along with their decisions. We've had a rule for a long time, and I always tell my law students, if you want to sound like you know a lot of law, just use this phrase whenever possible, and that is, non-mutual offensive collateral estoppel is not available against the federal government. Work that into anything and you sound like a real freaking lawyer. But what it means is this: if the federal government is sued by person A and person A wins, and then they're sued by person B can't just say, we win because you already lost this case against person A. They have to litigate the case all over again. Now, frequently, the federal government will just say, that's okay. We're going to go along with the previous decision. It's not worth going back. But in, for example, an immigration case involving some Filipino veterans who were entitled to U.S. citizenship, but were never given the necessary paperwork deliberately, the district court said that they were entitled to, but when it came up again in another setting, the Supreme Court said the federal government's not bound by that earlier district court decision because non-mutual offensive collateral estoppel is not available against the federal government. If you sue Walmart like that and they've lost a case on that point of law already, they just lose. But government on that, it's like it's too important that the federal government be able to decide things on its own, and that one president not be bound by a decision of an earlier president not to appeal a case or something for the courts to do that. That's black letter procedural law, and it's something that really illustrates the notion that the executive is not simply at the beck and call of the courts.
Excellent.
But
Thank
just
you.
remember,
Yeah.
non-mutual offensive collateral estoppel is not available against the federal government. I challenge you to use that in a conversation in the next 24 hours.
I love it. So I'm going to open this question up to the entire panel, whoever wants to take a stab at it. What would be the best approach to putting an end to bench legislation? Anyone have any thoughts or solutions there or anything like that?
I mean,
I
I
would
think
return to the three-judge district court rule for any nationwide injunction, any TRO against the federal government that applies to more than individual parties, and the like. And I'm sorry, I stepped on Will.
No, that's what I would have said. The suggestions. There's already a bill, I think, that's looking to kind of rein in on the TROs on this front that is along those lines. I think that would be good. I think maybe some more jurisdiction stripping, more affirmatively saying, I mean, apparently there was a lot of jurisdiction stripping in the immigration context, if I recall correctly, and there's not a lot of much role for Article 3 judges, but yet they've somehow found a big role. Maybe that needs to be rolled back itself and made clear that there is not much of a role here.
Do you have anything to add, Professor Jacobson, before I
Nope.
move on?
Nope.
Okay. All right. So I have another question from our audience too, and this individual shares a frustration which I have, which is that Congress is doing nothing to intervene in any of this when they do have at least a little bit of power and a little bit that they could do. What is your best guess as to how this will play out? Will the Supreme Court knock down nationwide injunctions? And what will reasonable due process turn out to be?
During the argument, there was a lot of attempts in real time by some of the justices to talk about alternatives, such as requiring class action certification as opposed to, nationwide universal injunctions. I'm not sure how effective that is because I think the core problem here is not procedural, it's cultural. We have a culture, a judicial culture, which believes it is supreme and believes, so many of these judges' opinions, and all judges, not just liberal judges, a lot of judges write knowing that their introduction is going to be kind of quoted by people. It's almost like the judge's press release is the introduction to the opinion. But a lot of them start with very flamboyant language, very much opining on the fact that the judge does not like what's going on. And that's a cultural problem. You can have a 3-judge panel and I'm not sure you're going to solve that. You can require the judges to certify classes of people. They're going to do it. Some have already done it. Okay. I think Judge Boasberg certified ex parte immediately a class consisting of every, Venezuelan gang member who's potentially subject to the administration's executive action. Crazy stuff. When you have that culture, I'm not sure there's a procedural mechanism that's going to solve the problem. And that's why I'm not sure how this is going to end, but I'm not sure tweaking the procedures might help a little bit, but it's not going to solve the problem.
Well,
Anyone want to add? I think Professor Reynolds has frozen. We'll wait just a second.
Yes.
You change the culture of the federal courts is by chance. I am very much in favor now. I can hear you.
Okay, so you froze a little bit. If you could give us, but you're back. So if you can just recap that, because I'm sure it's a really good answer and I would love to hear it.
Culture is people, and the way you change the culture of an institution is you change the people. And in the federal judiciary, we need to change the people there, and we need to do so by expanding it. People have been saying, neutral, nonpartisan, at least allegedly, groups have been saying for a long time that we need to add Court of Appeals judges in particular and district judges. If we do it, people will say it's political, but if Democrats do it, they'll say it's not. That means nothing. It needs to just be done. And if the Democrats come back and want to pack the court some more, that's a game Republicans can't really lose. If the Supreme Court winds up with 60 justices, I actually once proposed sort of tongue in cheek to make it 59. And in retrospect, I think I was actually right. But if it expands to the size of a legislature, it will get the respect that a legislature gets. And given the way it's acting, that's the kind of respect that it deserves. It's not a priesthood. They're not priests. They lack the necessary faith and probity. So I think that's a perfectly fine arms race to get into. It's got no downside for conservatives and Republicans down the line. And in the meantime, it will also send the signal to the trimmers that there are costs to letting the resistance take over part of the federal judiciary and run free because you don't want the New York Times and the Washington Post to say bad things about you.
For those who aren't aware what a trimmer is, can you explain that?
Well, it's a phrase when you trim your sails to suit the prevailing wind is one of the terms, but it's somebody who lacks the courage of his convictions and is always trying to adjust their views to be in the majority. That's, I think, a very fair description of Chief Justice Roberts.
Yeah, Chief Justice Roberts once had a famous comment that there aren't Obama judges and there aren't Trump judges. I forget which two presidents he compared, but if you knew nothing else about the case other than it was somebody against the Trump administration, and the only fact you knew about the case is who appointed the judge, you cannot predict it with certainty, okay? But it's probably a high likelihood that you could predict it. And it's true. And it's unfortunate, but it's true. There's a reason Democrats are going to districts where all of the judges have been appointed by Democrats. And so changing the people. I don't know if I like the idea of expanding the Supreme Court, but I do like the idea of expanding the courts of appeal and getting more of, quote unquote, our judges on there. I think people underestimated how effective the Biden administration was at getting their people in the district courts. Republicans didn't fight a tenth as hard as Democrats fight on judges. And we have some really wild characters who were appointed in the last 2 years, particularly. And they got through in part because Republicans didn't show up to vote. One of the judges, and I don't remember specifically which case, but it was one of the earlier cases. And it was a crazy ruling. I don't even know if it held up on appeal, but it was a really crazy ruling. It was by a judge who was either the second or third to last judge appointed by Biden. And the senator from Indiana, who's now, I think, the governor, didn't show up to vote. And that judge got passed. I think it was 50-49. Kamala Harris was no place to be found, so she couldn't post-election, so she couldn't cast the tiebreaker. But a Republican senator, Braun, didn't show up to vote. And if he had voted no, it would have been a tie, and that judge, who we're now stuck with for life, would not be on the bench. So Republicans really dropped the ball. Biden really packed the district courts. He did a very good job, and that's a very underreported fact. So expand the number of district court judges, because Democrats have been screaming that we don't have enough district court judges. They've been screaming we don't have enough Court of Appeals judges. They don't really care how many we have on the Supreme Court. They just don't like the ones we have. But numerically, they've been screaming about the district courts and the courts of appeal, that they're understaffed with judges. Fine. Add 30, 40, 50, 60 district court judges, and let's get them all nominated and confirmed in the next 2 to 3 years.
Sure, let's just do that. No problem, right? I do have another question from our audience. Newt Gingrich just during testimony suggested Congress can defund and dissolve individual inferior courts, which Congress has ordained and funded. What say the panelists?
Yeah, I think that's right. That's my understanding. I mean, the Constitution only requires the establishment of a Supreme Court. Everything else is under, it can be appointed by Congress. We talked about jurisdiction stripping. You can actually abolish judgeships too. It's actually a much more efficient means of changing the composition of the judiciary than impeachment. And I think that should absolutely be on the table. One basic concept I have that applies to a variety of political issues is you really shouldn't worry about doing unprecedented things. Sorry, you really shouldn't worry about setting bad precedents when you're constantly complaining about your opponents doing unprecedented things. And that's, I think, something people should keep in mind. I'd like to see us be a first mover for once.
Anyone else? And then I have another audience question asking if it's possible for the public to sue these groups and organizations engaging in lawfare that are impeding the executive's agenda.
I don't think so. I mean, you either win in court or you lose in court, okay? Now, the Democrats did something that Republicans don't have the stomach to do, which is Democrats engaged in an organized effort to disbar Republican lawyers. I think it was David Brock proudly announced that he was going to make Republican lawyers toxic. I think that was his word. And they had an organized effort after January 6th to get people disbarred. And in some cases, they were successful, but more important than the number in which they were successful is they scared everybody.
Yes.
Okay. And Republicans don't have the stomach to do that. So I don't think you can sue. I don't think the general public can sue a litigant. The court decides you're either right or you're wrong. But Republicans just don't have the stomach to do the dirty tactics that the Democrats did against Republican lawyers. So I'm not sure that in response to that question, there's a lot the public can do unless you're willing to become a Democrat.
I have to say, I hope the Republicans get the stomach, because I'm a big believer in game theory. And one of the key rules of game theory is that when you have iterative games between the same players, the only thing that prevents cheating is a strategy called tit for tat. It's the most successful, and it literally just boils down to do to them whatever they did to you last. And that, more effectively than anything else, prevents cheating. And we have not seen that. The Democrats keep cheating more and more and more. They will go further and further and further until it becomes too expensive. And the only way to make it more expensive is to do to them exactly what they've done. And people will say, oh, an eye for an eye makes the whole world blind. Actually, an eye for an eye makes people very careful about putting out other people's eyes.
I completely agree. There's no accountability, and there's no one to punch them back in the face when they do these boneheaded things, and it needs to happen. It does 100 times over at this point, because they certainly have a lot coming if we do end up playing tit for tat. Let's see let's move to this one. This is a question for Will. Moving specifically to the Abrego Garcia case, what do you think is going to happen in that case?
I think they will either have a hearing in absentia, or they'll manage to arrange a hearing in El Salvador where they're going to get his withholding of removal lifted. The withholding of removal was granted on tenuous grounds. And in the first place, I think it was based on a bunch of lies. But even then, it was based on this idea that the 18th Street gang was threatening his mother's pupusa shop. Well, the 18th Street gang is no longer even in operation in El Salvador because Nayib Bukele's destroyed it. Also, he's MS-13 pretty clearly, and ever since President Trump designated MS-13 a foreign terrorist organization, that makes him ineligible for withholding of removal, because withholding removal is only available to non-terrorists. So in either case, he should lose that withholding of removal, and that seems like a really elegant way to solve the problem. I don't think he's ever going to come back to the United States. If he is, it will just be to get immediately whisked back into detention and deported again. He's never had legal status here.
Right.
He's not a Maryland father, et cetera. But that's what I'd say there.
And I have one other case-specific question for you. Do you think the Supreme Court will come to its senses concerning the Alien Enemies Act?
Yeah, I do. I eventually think they will. I think they'll realize that, or at least basically, I think they'll validate only two challenges. One is to the constitutionality, but I think that's not really, that's kind of a silly challenge. The Alien Enemies Act was enacted at the time the Constitution was enacted. It's the same people doing it. So I don't think that'll ever work. There will have to be some sort of process whereby a person can raise their hand and be like, I'm not in Trinidad. Like, I'm not one of those people. So whatever that looks like, it may ultimately just look like, a 5-minute immigration court hearing where you get a chance to be like, what's your evidence you're not Trinidad, and they can present it. But that's essentially the only thing. I think that they'll come to the conclusion that in terms of the declaration of that there is a predatory incursion and that this is the class of people that needs to be barred as a result of the predatory incursion, I don't think the Supreme Court will accept that the judiciary has any say about that ultimately they will have to defer. But I think they're reaching. You can tell what matters to them. They don't like the administration's immigration policy, because if they were okay with it, they wouldn't be so aggressive about enjoining it.
Thank you for that.
And I think
I honestly think Robert's strategy is to run out the clock. I think Roberts wants to run out the clock till the midterms, and we've seen the Supreme Court actually do this before in the George W. Bush administration with regard to the detention of a lot of Al-Qaeda people at Guantanamo Bay, and they did successfully run out the clock until the 2006 elections, and the issue went away. And I think we're seeing something similar here. The question is, how is Trump going to respond? One of the things Trump could do is suspend habeas corpus, which would make a lot of these appeals go away. And that opens a whole new kettle of fish, but you can deport a lot of people before you get a ruling on that.
And I think how this plays out is extremely important. And I think the Trump administration, they've made some legal missteps, but they've done a lot of smart things too. And I think picking TDA, I'm not going to try to pronounce it properly, picking this particularly vicious gang, which is very tied into a foreign government, as the first case, I think is extremely important, because I think once they get over this hurdle, I think you're going to see the Trump administration roll out the same procedure and same sort of declaration for a lot of other bad actors and bad gangs, particularly related to Middle East countries, things like that. So I think that they were very strategic, I think, in picking this as the first one. And I'd say one thing I do want to give a shout out to, and I don't know if the other panelists agree with me, but the civil division of the Department of Justice, in my view, has done an absolutely phenomenal job at responding to this complete avalanche of pre-planned lawfare. And they don't win every case, but they win a lot of them, more than gets press. And they have fought really a heroic battle to hold back, the flood. So if there's anybody here who's from the civil division or knows anybody in the civil division, I think they've just done an amazing job.
Hey, I have just a couple more questions and then we'll get your closing thoughts. I'm going to start with Professor Jacobson for this one, but I'm curious about everyone else's thoughts on this as well. So we know that Trump has been, like we've talked about, has been very careful and he hasn't disobeyed any of these court orders, despite what the media has said or led people to believe. And he said that he will obey and he'll behave himself. But should he pull a Biden in the spirit of being tit for tat? Should he pull a Biden?
Yeah, well, Biden on the student loans didn't quite say, I will not obey the court, but he came pretty close to that. He said, I'm just going to figure out a way to do it another way. And he did in fact disobey courts, not necessarily the Supreme Court, but he did disobey district courts when it came to a lot of different matters. And it got relatively little coverage. So I think you may see the Trump administration move in the direction of, we're going to get it done another way. What that other way is depends on what the issue is, and that it is definitely true. If all you did is read the mainstream media, which isn't so mainstream anymore, I guess the legacy media is the more, you would think Trump is out there refusing to obey orders all the time. And the fact of the matter is, I don't think there's ever been a single judicial order that he has refused to obey. Unlike the Biden administration, which just did whatever they wanted until you had to go back to a district court judge 2 or 3 or 4 times. I think he may get to the point that he has to pull a Biden.
Anyone else?
I just add that in some ways, Trump is want to think about performing for an audience of one. John Roberts is the one who needs to get off the dime. John Roberts apparently cares a lot about his view of the Supreme Court as an institution. If I were Trump, I'd keep my mouth shut, which this term he actually seems capable of. But I would have a lot of surrogates out there talking about adding 6 members to the Supreme Court, about jurisdiction stripping, basically about stuff that will make the life of John Roberts worse and less successful, and cause him to be remembered as a failed Chief Justice. And if he sees that as a real threat, he will set his trimmed sails the other way, and suddenly you'll see a deep concern with the structural aspects of the Constitution and separation of powers. I guarantee it.
I like the way you think. Do you have anything to add to that, Will?
Not on this topic, no.
Okay. All right. Well, I guess if we can just go around, maybe we'll start with Will, then Professor Jacobson and Professor Reynolds for closing statements.
Yeah, I mean, I think everybody's right that, how do you define a constitutional crisis is obviously a vague term. That's just one that Democrats exploit. But I think the fundamental, the key point, as I said from the beginning, is this is being created by the judiciary. It's not the presidency that's encroaching on anybody else's powers, even if he's disturbing some settled understandings and doing things other people haven't done before. What the courts are doing is encroaching on clear Article 2 authority, and that's the actual crisis.
Yeah, I agree. I think constitutional crisis is when Democrats don't get what they want. But I think we have a credibility crisis. I mean, I think we came into this presidency with historically low trust in the judiciary, and they're living up to that lack of trust, frankly. The Supreme Court should have gotten a handle on this issue early on. Everybody knew this was pre-planned. Everybody knew what was coming. And in the first couple of weeks, you had some really crazy 1 a.m. ex parte temporary restraining orders, which decapitated the Treasury Department. And Supreme Court just looked at it. And when the administration tried to run to them, they did a little this, little that, but they never rebuked the lower courts, which they should have done. Of course, John Roberts publicly has rebuked Donald Trump, but never, and the administration, but never the district courts. And I think John Roberts should use his bully pulpit, which he doesn't hesitate to use, to publicly rebuke the district courts. And I think that would go a long way, not all the way, but that would really help. So I see this continuing. But most of what Trump is doing will survive. It's just been slowed down.
And last but not least, Professor Reynolds, do you have anything to add in conclusion?
Well, one of the big slogans that we heard from the left, starting actually after the 2016 election, and then repeated this time around, was don't normalize Trump, denormalize Trump. This is not normal. Well, what they have done is they have denormalized themselves. They've denormalized American institutions by perverting them to this monomaniacal cause of resistance to a duly elected president who is doing exactly what he promised the voters that he would do. And the notion that that is somehow worthy of resistance, worthy of perverting the courts, worthy of perverting the press, worthy of perverting all the different branches of the government, including the allegedly non-political civil service, is, I think, itself monstrous and destructive, and has denormalized not only institutions, but to some degree, America itself. It's not the country you learned about in your civics books, where you have elections and you thrash issues out, and then you live by them and you agree to go away and be good citizens until the next election. Not at all. It's war by any other means, and that's what they've chosen. And I think that it's going to play out that way until at some point it becomes too expensive for it to continue that way.
Thank you all so much. And I know that, this is a very important issue, and one that we've dealt with repeatedly over the course of our nation's history, but seems to be a pretty prevalent one now. So I really appreciate you taking the time to share your knowledge and wisdom and your thoughts on all of this. And again, we thank y'all for your time. We hope you found this very informative. And again, thank you to our panelists. And y'all have a great Sunday and a great week ahead.